Good evening. There can be no equal justice where the kind of trial a man gets depends on the amount of money he has. Those are the words of Justice Hugo Black in Griffin v. Illinois, 7 years before he authored his groundbreaking opinion in Gideon v. Wainwright, establishing a Sixth Amendment right to counsel in state court prosecutions. Welcome to a very special edition of Chas Calenda, Attorney at Law on the Coalition Radio Network. Our purpose tonight is nothing less than to provide a platform for discussion of the role, the challenges, and the future of the public defender system. Joining us tonight, Chas Calenda is an attorney at the law firm of Inman and Torgy in Coventry, Rhode Island, where he practices in criminal defense, civil litigation, and constitutional law issues. He was formerly a state prosecutor at the Rhode Island Office of the Attorney General for 12 years and is now a candidate to be the Rhode Island Attorney General in this year's general election. Jonathan Howe is a staff attorney in his fourth year with the Bronx Defenders Family Defense Practice. He is a graduate of the Benjamin N. Cardozo School of Law in 2018. He is currently a candidate for the United States Congress District 14. If that sounds vaguely familiar, it should be. He'll be challenging none other than Alexandria Ocasio-Cortez. And of course, Mark Rutherford. Mark Rutherford is an owner at Thrasher, Bushman, and Vogel PC in Indianapolis, Indiana. His bar admissions, well, they read like, if you will, a National Geographic of the law. Wow, Indiana, 1986. U.S. District Court, Southern District of Indiana, 1986. U.S. District Court, Northern District of Indiana, 1990. And of course, the Seventh Circuit Court of Appeals in 1994. His areas of practice include business law, mergers and acquisition, election law, commercial litigation, white collar, and of course, constitutional law. His nonprofit law experience is equally astonishing. The Marion County Superior Court's public defender. He was a Marion County Prosecutor's Office deputy prosecutor. Since 2007, he has served as chairman of the Indiana Public Defender Commission. He's a graduate of Valparaiso University School of Law. The combined experience, boots on the ground, expertise, both legal and of the street tonight is simply astonishing. The Coalition Radio Network is proud to host these three gentlemen. I'm going to just throw out some questions to the room, and then we'll let you guys take over. Mark, from your perspective, as someone who literally administers the public defender system to a degree in the state of Indiana, what is the state of the public defender system in America today?
Well, it's disjointed. In some perspectives, it's very, very good. In other perspectives, it's lacking. And I know Indiana the best, and I'll give you an example. The General Assembly has been adding more and more money, and the Public Defender Commission here, we basically distribute money to counties who abide by our standards. We've got about 2/3 of them now. But the money is not allowed to be used for misdemeanor defense. It is for felonies, for CHINs, which is Child in Need of Services cases, where there's allegations of children needing to be placed somewhere or taken from parents, etc. And there's a possibility of jail time in some of those cases. So they're entitled, and they get public defenders now. And the commission for those counties that do it, abide by our standards, we subsidize them greatly with money to do that and to give them an incentive to do that. But misdemeanors is where most people who have touched the criminal justice system will touch it. Yet it can have an incredibly bad effect on somebody's life. I'm hoping eventually we'll be able to do that. I'm hearing some good things. I think eventually it will. But my point being is, in some matters, the public defense is really quite good. In other areas, in other matters, it's not at all or non-existent. And when you go to other states, it's often the same problem. Some states are better than others. There is that out there that public defenders aren't as good as real attorneys. You hear that a lot. But we know, who are involved in the system, that some of the best litigators in the nation on criminal defense are in the public defender system. They try cases, they do cases, they know how to work with their clients. Now, and one thing, though, that is really neat is that I know in Indiana, a lot of legislators are beginning to understand what we keep saying, which is we think we save the taxpayers money because our public defenders, especially, are not as overworked because we set standards on maximum number of cases that they can have. And we've been able to show, and it's still kind of anecdotally, but we're beginning to get the statistics, the facts from all the different court systems together to show that fewer people who have a public defender that's in the public defender commission system, where they have a requirement that they don't have too many cases, they're able to, most people end up pleading or convicted. It's just the way it is. And they get appropriate sentences. But what's wrong with that's great. Why is that? If you get an appropriate sentence, it will help rehabilitate you. And that's in the Indiana Constitution. And so recidivism is going down in those counties that are part of the public defender commission system. It's not every county, it's 2/3 of the counties, but it's saving taxpayers money. Fewer people in jail, fewer repeat offenders, fewer need for prosecutors, public defenders, etc. So that's kind of a long-winded thing about what's going on. But so I feel good about it. Since Gideon in the early 60s, things are way better, but way better is not where we should be because we're still not where we need to be. The court system, criminal court system, is very overwhelming. It's even confusing to a lot of lawyers, let alone somebody who doesn't know what's going on, and they make mistakes all the time if they try to represent themselves or if they don't have an attorney with the time to represent them well enough to get the message to the court on what's the best thing to do for my client.
Jonathan, from your perspective, you inhabit a wildly different world than many. When we talk about boots on the ground, your exposure to everyday life, the travails of being members of marginalized communities in a community that is in itself facing epic economic challenges. Talk to us about your experiences and what's happening in Bronx County Family Court.
Well, not much is actually happening at Bronx County Family Court because Bronx County Family Court has been closed since March of 2020 and it's not reopened. So I've been an attorney. I'm entering my 4th year now with the Bronx Defenders and as an attorney. So I have now practiced more court virtually than I ever did in person. There's benefits and there's drawbacks to it. A lot of my clients would prefer to have virtual court because if their case is going to go away quickly, they can just call in to a couple of appearances and the case is over. But for other cases, where an actual trial occurs, which happens a lot more in family court than in criminal court, if you're not in the room with the judge, you're not in the room with the person who's judging you, it's a bit different. I mean, I've seen trials where a parent is sobbing, hearing testimony about their child, and the judge will put them on mute and, put their camera to the side so they don't have to look at them. These are things that you can't do, physically in court. So the impact on clients in the Bronx it's been diverse, but whenever there's a change, whenever there's an impact, whenever there's a major, shakeup, it's always going to negatively affect, the people that public defenders represent the most. Another example would be I had clients who were living in New York City family shelters. They were in a shelter with their family. Not only could they not connect to court because they didn't have Wi-Fi, but their kids didn't get to go to school because they didn't have Wi-Fi, and they had to sit outside of coffee shops and out of McDonald's and try to get 30 minutes of free Wi-Fi at a time. And now they're already in the family court system, because they're my client, and now their kids are missing a lot of school. And yet they put a little bit of freeze on filing education neglect cases for a while during COVID, but that's all going to add up. That's all going to come back to bite them. And it wasn't their fault at all. They would have been much better off with in-person. So as far as the state of just being shut down and not being in person, I would say it's a very mixed bag. I think that respondents and parties should have the right to have a mixed appearance, where people who aren't able to take an entire day off for an AM call can appear by video, and people who aren't able to appear by video because they don't have a technology can come into the courthouse, or just someone who wants the judge to have to look them in the eye can come into the courthouse. And just for context, I keep saying judge, not jury, because there's no juries in family court, at least in New York. But overall, the state, it keeps going back and forth. We keep taking a step forward and then a step or two back. Even just today, we had passed what's called the Preserving Family Bonds Act, which allowed someone who had had their parental rights terminated to still have a visitation arrangement with their biological children. That passed in the Assembly and in the Senate, and the governor vetoed it. But something that she didn't veto was a change to the state central registry, which is when you're investigated by the Administration for Children's Services. It used to be if there was any credible evidence, then your case would be indicated. That was the standard, any credible evidence, and it would be on record until your oldest child was 28, and it would come up if you applied for a job. Even if it never went to court, you were never found guilty, it would come up on your record. But they've changed that to a fair preponderance of the evidence. So now to have an indicated case, and this just changed in the last couple of days, and the governor signed that bill. So we took a big step forward in not having as many cases filed, in my opinion, but a big step back in that when you get to the worst possible end to a case, we didn't improve that. And I think it's analogous. I don't follow criminal law, the day-to-day practice quite as much, but we've done a lot with bail reform and not putting people in jail over petty crimes. I know the Manhattan DA just today put out I think controversial, but I liked it. List of things he wouldn't jail people over. But meanwhile, the jails are falling apart. The crime and the violence and the illness at Rikers is worse than it's ever been, even though we're supposedly emptying it out and putting far fewer people in there. So I have to agree with Mark. It is definitely a mixed bag. There's good and bad. But at the extremes, I would say it's getting worse.
And Chaz, weigh in on Rhode Island from your perspectives, your experience.
So obviously I come from a different kind of background. I started my career as a prosecutor, but I worked day to day with the public defender's offices and the court appointed attorneys that get appointed when the public defenders have a conflict. So, my experience with them was you usually get to work with a few of them very, very closely. And I know in 2000, I think it was 2015, 2016, there was a study done in Rhode Island that looked at kind of the public defenders' caseloads and the amount of cases that they're expected to juggle. And I think they looked at it that they had 49 full-time public defenders working in that office. This is the statewide office for the public defenders. And they would have needed to increase that number to, I believe it was 136 full-time lawyers in order to handle the necessary minimum level of representation for the 15,000 or so cases that they say were coming in each year. And, the public defenders of Rhode Island do a great job. And I think there's some of the best trial attorneys that you have in the state. And when I was a prosecutor, I'm no longer a prosecutor, but when I was a prosecutor, I'd often have people asking me, should I stay with the public defender's office? Should I go hire a private attorney? And I would often encourage people to stay with the public defender's office simply because a lot of them will develop a fairly good working relationship with the prosecutors, the judges. They have credibility in those courts because they're there all the time. They know what the judges, the prosecutors, and the courts are looking for, and they usually get as good, if not better, results than a lot of the private attorneys who come in and act like the bull in the china shop and cause all sorts of issues that don't necessarily need to be there. And now in my current practice, I do a lot of criminal defense. I'm a private criminal defense attorney, but I am on the indigent indigent court-appointed list, where I do take the cases from the public defender's offices when they have a conflict of interest. So, I'm in the system to a certain extent, and I take a lot of those cases in courts where it is convenient for me to take it, because they'll give you as many cases as they can possibly give you, just simply because of the sheer number. So, for me as a private attorney, I have to somewhat limit my ability to take the indigent cases, because if I don't, I will not have the ability to take on the private cases. But I do it because I really do believe in the system that requires the state to be held to its burden of proof, that requires and encourages and makes sure that everybody has a zealous defense. And unfortunately, especially when I was first starting out as a lawyer, you saw the same kind of cast of characters doing these indigent court-appointed cases, and they weren't doing it because they loved what they were doing. They were doing it because it was easy billing. And it was unfortunate. And I think the judges were starting to recognize that. And they're doing everything they can right now. I know in the family court, there's not a whole lot of criminal work that gets done in our family court, except for the juvenile prosecutions, where the public defenders would be involved. And some of the adult neglect charges, they do have some of the public defender involvement. But I know that there were maybe 3 repeat attorneys that were just taking all the cases, and they're going out of their way right now in the family court to try to get more people, but they're paying them $30 an hour. They're paying them $30 an hour, these lawyers, to do that, and they just can't find enough good people. So while I have a whole lot of respect for what the public defender's office's abilities are as attorneys, because and I say it to everybody, they're excellent attorneys. They're understaffed, they're overworked, and they just don't have the ability to give the attention to their cases that they really do need to give, especially when you have they're fairly new attorneys in their office that are expected to handle the gamut of the cases, the run of the gamut. You have murders, you have major felony cases, all the way down to misdemeanor cases, and it does affect the quality of the representation. So I do think the General Assembly here in Rhode Island does need to look at that and properly fund not only the public defender's office, but the ability to pay the private attorneys who are willing to take these indigent defense cases as well.
You bring up a critical point, and of course it's economics. And that's always been an issue in and around and surrounding public defense. With law school costs approaching $100,000 to $150,000, depending on whether you go to a public or private law school, and the amount of debt that one takes on, either by school and or starting some form of practice independently. Is it possible for states to pay a fair wage? And let me throw this out to the gentleman from Indiana, New York. What type of compensation, whether it be hourly or salary, are being afforded folks in the system? Mark, why don't you jump in?
Sorry, Pat. At least for me, you just broke up at the end there, Pat. I'm not sure if we.
Yes, you
at least
did.
I didn't hear you.
Yeah. So I guess what I'm looking at is you've got these enormous academic costs. You've got the potential for huge student loans hanging on the shoulders of anyone who's a recent grad from law school. In addition to that, you've got challenging compensation levels. What's your reaction to that, and what type of compensation is available to folks in places like Indiana and New York City, 2 wildly different economies?
Well, Pat, let me tell you about what happens in Indiana. One of our standards in the commission for those counties who do it, and they get money to help subsidize it from the state, and that is comparable pay to the prosecutors and to the deputy prosecutors. So that's a big thing right there. So they're getting an okay salary. Prosecutors here are making, and by Indiana standards, Indiana is still not as expensive as some areas in the West and East Coast. You're seeing them making $65,000 to $80,000 starting off. I know the Attorney General's office, the more experienced ones, are making in the middle $150,000 or a little bit less than that. So the price is not bad, especially if you have the loans to pay it off. It's still not as good as private practice. Private practice, if you work hard, you can really pay those loans off more quickly. But you do get good experience. There's a lot of things about working for the state as a public defender that's very, very beneficial. And then we do have some counties that are too small that they have hourly rates, but the hourly rate is not competitive with the private attorneys, but it's still fairly good. And they're getting $80, $90 an hour in those counties. And in a small town where the commercial buildings are not that expensive, in fact, a lot of them are vacant, and they're available, the costs are down. So people can make a good living, or more importantly, they can use that money as guaranteed income to make sure that they can pay the bills. And if they have a bad month with the private clients, if they have some, then the part-time public defender work kind of subsidizes, make sure everything gets paid. So there are benefits. Do they get paid enough? Well, I'm not so sure they do, the public defenders, because it's so costly to go to law school. And it's so costly, especially in a city like Indianapolis, to rent space and have offices, et cetera. But Jonathan kind of mentioned this about video conferencing. In Indiana, most of our courts are open now, pretty open. But what the judges learned through the video conferencing is they were asking the litigants, the defendants, and their attorneys to come to court personally too long, to sit around, wait an hour until their case got called for a 3-minute need. And now with the video conferencing, everybody loves it, because now I don't have to drive to a court or walk to a court, and I hang at my desk, I do some work. My clients, sometimes in my office, sometimes they have the ability to do it. If they don't, they can come to my firm to get the internet access. And it's over with. I mean, I bill a 0.1, which is 6 minutes, instead of an hour and a half, because I have to wait there. So everybody's liking that, and it's saving everybody time. The courts are happy that the courtrooms aren't packed with people. They're only packed with the people that need an in-person hearing or trial.
Interesting. Chaz, reflect, if you will, on Rhode Island and its use of technology.
Rhode Island's been pretty slow with its use of technology, and it's surprising because only in 2015 did they even start using electronic filing. And in my understanding, that was pretty behind the times for their court filings. Right now, during the period of COVID, the only, for a while they were doing mostly remote hearings, even in the criminal sense, unless there was a contested hearing or a contested trial. They weren't doing trials for a long time, which was a constitutional problem, in my opinion. But now it's back to pretty much all in person for all criminal cases. The only court that's really using remote hearings is the family court, because just like Jonathan had mentioned, they don't use juries in the family court in Rhode Island, and the judges have just in the Rhode Island family court, and I'm just going to say it out there, the judges have just loved the idea of the fact that people don't have to come to court. They can schedule it. They can have their 5-minute conference, and they can avoid doing the hearings that they would otherwise have to do, and kind of force people to talk out their cases. So family court's really the only one doing the remote hearings now, unless there's like some sort of a COVID breakout at the ACI or the prison here in Rhode Island, where they have to have a remote hearing because they can't bring the person into the courtroom. So, I've been, even through the entire time of COVID, for pretty much, I've been in court because the bulk of my practice is criminal defense. So I've been in that courtroom all the time.
Let me throw this out to Jonathan. As someone like myself who's not an attorney and clearly not an expert, we understand how the pleadings, perhaps the trial conferences, the arcane mechanics, if you will, that take place in litigation or in a criminal proceeding would work well in that. But and maybe like so many folks who are novices to the legal system, we place too much emphasis on what Chaz calls that Matlock moment. But is it possible to really, and particularly on the more troubling cases, both criminal and family, is it possible for someone to get a fair trial and impact, particularly, say, a jury, if we continue this move to electronic? what is the power of in-person judiciary?
I mean, when you're in person, you can communicate not just through words, through body language, through facial expression, through the way that you hold yourself up. These are all things that we know that judges and juries are looking at. And a lot of times, and at least in my experience, the judge is not looking at that. They're not able to look at that. They got a screen up with 20 people on it. They have an attorney for each respondent. They have an attorney for the children. They have an attorney for ACS. They have an attorney for everyone. And then they're also taking their own notes because there's no person transcribing. So they like to take very detailed notes so they don't have to order a transcript. So it seems like it's very easy, even easier than it was in the past, for a judge not to pay attention to what's going on. And even when they do pay attention, it's not possible for them to have that human experience with someone. And I know I mentioned this before, but when you're in a courtroom and you're just a few feet away from a mother who's testifying, about her child, or someone else is testifying about that mother and her child, and you're seeing the mother break down and cry, it used to be when you were the judge, you took note of that. Now it's just a distraction on your screen. You can mute it, you can turn it off, you can do whatever. So, I mean, in cases like that, I don't think it's possible to get a fair trial. And in cases where a lot of it has to do with overcoming disbelief of your client's credibility, and like you really need to swing for the fences and have your client, testify really well and make an impact on the judge, it's a lot harder to make an impact on the judge. Now, on other cases that are just, I don't want to say more routine, but the cases where you kind of know where it's going to go before it begins, we have a lot more trials in family court, but the standard is preponderance of the evidence. So the standard is a lot lower. It's a lot easier for a public defender or for any defense attorney to lose a trial. So in cases where you kind of know where it's going, where clients just didn't want to take a plea and they know what's likely going to happen, it's good because they don't have to take the entire day off of work 3 or 4 separate times to come in for 1 hour of trial and they'll go home. Because the way we do it in family court, we don't set aside a whole day for a trial. We set aside 30 minutes to 2 hours at the most. And then you schedule to come back again, and then you schedule to come back again. So for clients who just want to get it over with, it's great, but I don't consider that fair. And for clients who really need to, make a human impact on the person passing judgment on them, no, I don't think they can get a fair trial. So again, going back to the earlier question and my earlier answer, the people at the extremes, the people who need it most, are the ones being the most impacted. Where the people who are kind of more in the middle of the spectrum, as I think what Mark was saying, like it's a lot easier a lot of these times. You have your 3-minute meeting, you're in, you're out, and I definitely appreciate that. One of the reasons that I decided, finally I'm going to run for office, well, I just kept sitting at home thinking, like, I am saving so much money right now. Like, I'm not commuting, I don't have to eat out, I don't have to do this. And then I would get a call from a client, be like, I haven't seen my kid in 2 months because there's no visit to the children's center because of COVID. And so I'm doing fine. I'm a public defender. I'm a big hotshot lawyer. The people that the government is supposed to be helping are the ones who are suffering the most.
So
Pat,
Mark, go ahead. I'm sorry.
No, I was just going to say you can't get a fair trial if you have witnesses online. You just can't. It's got to be in person. Same with sentencing.
How are the court calendars being affected by this? And to Chaz's point, if you can't get a trial on a timely basis and you're incarcerated because of bail issues, or and that's an issue we're going to go down in terms of potential reform issues. But how has this all impacted that? What kind of mess are we in there?
Well, Pat, what I've observed in Indiana, and actually the sheriffs in Indiana who are elected are kind of leading this to a large degree. We're putting fewer and fewer people who just annoy us and leaving the jails and prisons for those that scare us. That's the best way I've heard it put in a simple way. So the violent are in jail. The people who aren't violent are getting bail. They're getting released on their own recognizance a lot more. And so that has been a good effect in Indiana. There's been bail reform based on what is happening and with everything that was happening. So there's been some good along those lines, and that's nice to see.
Chaz, your thoughts?
Yeah, I agree. I agree with Mark. Like, you cannot have a fair trial, a contested, legitimate, fair trial over over a remote hearing, just because of all those intangibles Jonathan was talking about, the ability to to look somebody in the eye, observe their nonverbal cues. And any experienced trial attorney is going to tell you that would be an impossible situation for him to do. And when the civil cases here in Rhode Island were having contested hearings remotely, both parties had to agree here to do it remotely. And I would routinely object to that if there was going to be an argument, because I just didn't think it was going to be heard in a way that was going to be fair to my client. We can't have jury trials on a platform such as this or Zoom or WebEx. It just doesn't work. So now in Rhode Island, and at least in the criminal courts, they have, we call them the ice boxes. So there's 2 courtrooms, I believe, in Providence, our biggest city here, two courtrooms out of probably about 20 that are being used for jury trials. And I call it the ice box because each seat is divided by plastic dividers on 3 sides. So you feel like you're sitting literally in an ice box. And then the other counties, there is, they're not even picking the juries in the other counties. They pick them in either one of the 2 bigger counties, and then they send them down to the smaller counties to go sit there and hear the trial. But they're really not doing a whole lot of jury trials right now. Even still right now at this very moment, a lot of cases people are opting for bench trials, even in the criminal case, which is as we all know, doing defense it's a risky, very risky proposition to have a judge deciding your guilt or innocence when they normally are just kind of presiding over the trial, and the jury decides your guilt or innocence. So it's you got to have this goes back to the competency of the representation you're having. You have to have a lawyer who's defending you, who knows what kind of judge you're in front of in a criminal case, what their kind of predilections are, where they've come down in the past. Are they going to give you a fair trial? Are they going to pay attention? Are they going to do those things? And I'll be quite honest with you, I can only think of on the felony level in Rhode Island, where you're entitled to these jury trials all the time. I can really only think of 2 judges in the state that I would advise any client to even consider a bench trial on a felony case, just simply because of the idea of you only need to convince, the state would only need to convince one person, a judge who's seen thousands and thousands and thousands of these cases, of your guilt beyond a reasonable doubt. Whereas in a jury trial, you have to convince all 12 beyond a reasonable doubt. And that's a scary thought for a lot of people.
It certainly
I'll
is.
just add to that if I can.
Please go ahead.
Oh yeah, I was just going to say, in family court, the judge that you have when you're arraigned, the first day that the case is filed, is the judge that you're going to have at trial. And it's also the judge that you're going to have during emergency hearings pending trial. So an emergency hearing would be like a hearing to have your child returned to you pending trial on abuse or neglect. And in those hearings, hearsay is allowed. All the rules of evidence are out the window. You can really put anything into evidence. And it's the same judge who's going to be doing your trial later, where hearsay is not allowed. And so they have to pretend like they've forgotten everything that they heard earlier, all the hearsay, and then preside over a new trial. And it just seems like a no-brainer that you would need to have a different judge. It's just not enough. So they wouldn't even consider giving you a different judge.
So from all of your experiences, I'm sorry, go ahead.
I was just going to say, how does that even work? Because I know family court runs a little differently, but in the criminal cases in Rhode Island, and even the family court cases I was handling, in the juvenile prosecution division, the judge that you're in front of, usually at the very beginning at your arraignment or your initial hearing, is almost never the judge that's going to oversee your trial. And I think that's a good thing, because a lot of stuff is talked about, like you said, that probably is not admissible at a full trial just under the rules of evidence. So I mean, we're supposed to presume, I know, we're supposed to presume that the judges can put out of their minds the inadmissible hearsay, the things that were talked about, the pretrial conferences that are all discussed. But, really, can you ever unring that bell? That to me it's mind boggling.
You cannot unring that bell. It would be one of the first changes I would make if I was running for a state level position. But
Sure.
again, you can't make a constitutional argument really as strongly against it, because you don't have a constitutional right to these trials. You don't have a constitutional right really to your children. You don't have a constitutional right. Gideon doesn't apply to family court. It just so happens that New York State, in its infinite wisdom, decided to give attorneys to parents in family court. I think every state gives attorneys to children in family court, but I don't even think most states give attorneys to parents in family court. So yeah, I mean, it's a totally different level of railroading people who are brought in by the state.
The question begs, from all of your perspectives, and it's impossible to apply a number, so I won't ask that. But if you can give us a general sense of how many folks end up in that what's often euphemistically referred to as the pipeline to prison, and end up incarcerated or having family separation, often on a permanent level, because of their inability to manage the system both before and after COVID, for that respect. What kind of impact has it had on people?
I mean, I guess I'll jump in. It's been huge. I mean, it's been absolutely huge. If someone else wants to jump in, it's just,
Yeah.
I think it's kind of what I was just talking about. That sorry, go ahead, Chaz.
No, you're right, Jonathan. I think it's been absolutely huge. Pre-COVID, post-COVID. I mean, you just see I've seen it as far as people just not being able to get the attention to their case that they would otherwise be entitled to. And it's been especially frustrating for people who have potential no contact orders, restraining orders, and they're not able to go to their homes or be with their family or be with their spouses, whatever it is. Right now the courts, although they're open in Rhode Island, they are still managing their calendars under an emergency type of schedule. So you have to get, where before it's just the typical 10-day notice to the other side. You schedule it, you get your case heard. Now you have to get approval from the judge before you can even get a case scheduled, even if you're doing it within the 10-day notice. And most of the times you're not getting that 10-day hearing. You're getting a date 30, 60 days out, and nobody will even consider even moving that up. I've got a case going on right now where there's a no contact order in place with a person. My client has already been declared basically incompetent, in the sense that he's an adult with a guardian over him, and that's pretty hard to get, I'm sure, as you guys know. And there's a no contact order now with this guardian, who has all the legal ability to make the medical and legal decisions on behalf of this person. And there's a no contact order. This person can't be part of that decision-making process for the medical and legal decisions. And the judges just will not set down a hearing to reconsider whether or not that no contact order on a case that's not resolved should remain in place, despite the fact that this person's already been declared unable to take care of themselves without this guardian. So that's just one example of something that I can point to that has been a very big problem, at least in Rhode Island.
So Pat,
the inability to file for a while. Sorry, go ahead, Mark.
Oh, no. So Pat, in Indiana, people with a misdemeanor charge are entitled to a public defender, but because there's no subsidization of the counties for what they're paid from the state of Indiana, they can have incredible numbers of cases and can't give anybody any attention. That's when mistakes are made. That's when you don't figure out what your client needs. that is where the problems happen. And misdemeanors really screw up people's lives more than some people might think, because it can have all types of effects in getting a job, etc. And oftentimes, if they had had somebody with the time, I think that a lot of them would not have ended up with a conviction. Do they go to prison in misdemeanors? Not unless they that often, unless there's a special circumstance, or which includes they just keep committing misdemeanors over and over and over again. But it does have that effect, and people, oh my gosh, it's so easy to get anybody's history in criminal history now across the nation. All the employers get them. They know that you shoplifted when you were 6 years old. I mean, I'm kind of, that's really not true. Most all juvenile records, most of them are never opened again once you're over to the public. But it's still a big problem. I think that with the felonies and the death penalty, we've made huge strides, but we've got to be more careful with the misdemeanors, because we're setting people up on a bad position. The legislature finally figured out, and that's not an attack on them, they've got a lot to do, but a lot of people did and worked with the legislature, General Assembly, to quit criminalizing a lot of driving offenses. It just created fines, and you took the license away, but they still had to get to work. And now it's just kind of more just fines, and it's just way more friendly and not a crime to do a lot of these things anymore. That were like driving while suspended. Why were you suspended? Because you couldn't afford to pay fines. Now we're going to charge you criminally. I mean, it was just and it became obvious that that was not a good system. So I guess to end this, I would just say that we need to deal with misdemeanors better and have better, because sometimes I think the misdemeanors and the way we handle them create the future felons.
Absolutely. And I throw this out to all of you. You know, there's a movement called Ban the Box, where, employees and employers are often tangling about criminal convictions on an employment application. It's very controversial because on one hand, an employer would like to know if they're hiring someone who was convicted perhaps of larceny or misappropriation of funds, and in a very common business example. On the other hand, the role of the criminal justice system is to, once someone does their time, as they say, is to allow people an opportunity to move on and regain the virtues of daily life. Has Ban the Box been passed in any of your states, and what's your thoughts on it?
Well, Pat, what Indiana does have, which has helped a lot, is that they have really made it easier to seal or restrict access to records if you've been good for a long while. It's called an expungement, and the record goes away. It's still filed away. Criminal investigators can still find out what it was, but it can't be made public. And employers by law are prohibited from asking any employees or applicants whether or not they have any sealed records or they have anything expunged. The only thing they can ask them about is stuff that is actually still in the public record. And I think it's been great, because a lot of people who are having problems finding jobs, but they've been good, they haven't had any problems for whatever period of time's involved, 2 years, 7 years, 10 years, there's all different types of standards depending on the crime and what it was. It gets cleared up, and it makes it easier for people to get jobs. So I think that's been a wonderful thing in Indiana, and I don't think employers really have been hurt by it all too terribly bad.
Jonathan, what are your thoughts?
I mean, I like the thought behind it. And I even like the effect of Ban the Box, but it's kind of like putting a Band-Aid on the wound that you caused yourself on purpose and then saying that you solved the problem. The problem is that too many people have criminal records, largely for victimless crimes or for participation in larger crimes. And we should have fewer people with criminal records in the first place. Ban the Box is a good way to patch over the damage that we've already done. I do have some issues on it, just on it's going to sound really silly, but on a free speech level. Like it's a contract between two people. They should be able to communicate however they would want, and the government shouldn't be able to get involved in that. But then again, on this issue, I do understand the reasoning of it, and it has been effective. And from what I understand, in other states, it's been effective as well. But it doesn't stop the problem, which it's trying to fix. We still need to fix the problem underneath it by giving fewer people criminal records that ruin their entire lives.
Chaz, in Rhode Island, I believe it was put into law in 2014. You've been engaged in criminal prosecution before and after. What impacts have you seen from Ban the Box?
Certainly, Rhode Island's law is that on any application, the initial application, they can ask for about criminal history or criminal convictions. But once you are selected for an interview or you move on in the process, then at that point, the employer or potential employer is able to request and demand that you provide them with a background check. In Rhode Island, they refer to it as your BCI. And, at that point, they make a decision about what's good for the business and whether or not you're a good fit. But, I can certainly see that in Rhode Island, they have expanded who is eligible for expungements and who's eligible to have their records sealed. And one of the things as a defense attorney that I like to do, if I can, especially on misdemeanors, because I agree with Mark's take on that the misdemeanors are where people get caught up a lot and they don't even realize just what kind of trouble that they can get themselves into just by having a misdemeanor conviction. But on misdemeanors in Rhode Island, there's something called a filing that you can get. So it's basically a withhold of adjudication where, your case kind of sits on the shelf for a year. And if you don't violate whatever terms that they may put on that filing or you stay out of trouble, the case gets sealed as opposed to expunged. And under Rhode Island law, a sealing requires the police department to actually physically destroy the police reports that they have in their possession, the booking documents, the booking records, all that kind of stuff. The court file itself, the complaint is shredded, although there is a remnant, there is a document that says a complaint was shredded, and all BCI records are sealed. So if you can get a sealing in Rhode Island, as opposed to an expungement, it's good because technically those records are not supposed to exist after that sealing happens. Now, I've run into a lot of situations where the police don't actually dispose of those documents properly. The court does not actually dispose of those documents properly. And theoretically, under the law, there's some civil liability to that, but it's hardly ever used in the proper way. But people are being denied their rights to purchase or own a firearm because of improperly kept files. Or improperly, files that have been destroyed that have not been destroyed that should have been destroyed. So I think they're trying to make headway in that, and they've made some, and I think it's been good for the most part. But there's still a long way to go in that situation because there's always exceptions to even the expungement and the sealing statutes that we have that are not always in the best interest of our clients.
I mean, the nightmare scenario is clearly, and let's talk to misdemeanors as an example of this, is that the inability to obtain high-priced legal talent, if you will, and by the way, I think everyone in this room right now is highly supportive of the public defenders who play a noble role in our country's daily life. Never mind the if you will, the criminal justice system. So everyone, I think, is very, very supportive, but let's take it from a perspective of just caseloads. Do you still find folks being encouraged to plead out to a misdemeanor in order to facilitate moving the case along, and then finding out later on in life, sometimes very much later in life, that bogeyman is still out there, and whether it be in many cases housing, access to professional licenses across the board, their lives are negatively impacted. Is that still happening?
100%.
Yes.
100%.
Yep.
What do we do about that? I mean, that's the great question. I mean, I've still got plenty of other questions, so kind of put that in the back of your mind for a second, because that's, I think, where we're going to close on tonight. But that, of course, is a travesty. And now that we're starting to see a sea change in what some people euphemistically refer to as victimless crimes, and cannabis is a leading example of that, and we're starting to discuss things like expungement, because we're recognizing it. How do we cut the bleeding now in terms of getting folks the information they need, particularly, and I, you know, the term marginalized communities is thrown around a lot, but when you're talking about folks who are maybe newly arrived to this country, who, you know, who don't have the a real sense of the American criminal justice system, maybe they have watched too many issues of Matlock or SVU, where all of a sudden they're just rescued from the that pipeline to prison at the last minute by a noble stroke of luck. I don't know. But how do we cut the bleeding there? What do we do right now to educate people as to the importance of those steps, that it shouldn't be just a knee-jerk reaction to just get out of the immediate situation?
Well, one thing
Well,
that the Indiana Public... Go ahead, Jonathan.
Go ahead, Mark. Oh, okay.
Okay.
Well, one thing you have to do is you have to make all the expungements automatic. Any expungement has to be automatic. Anything where you have to file to get an expungement for something that we've now legalized, I think it's just such an absurd idea. It's us, you know, us the people. I mean, we made a mistake. We shouldn't have had this illegal. Now spend your time, money, and effort trying to figure out how to get this done. And you know it's not going to be easy. You know it's going to be something that has to get notarized. You know, it's going to be difficult on purpose. So all of that has to be done, you know, automatically. There should be nothing for you to do, and there should be an easy way for you somehow to look it up and make sure that it got done. But the other thing, we have to stop the bleeding. Your marijuana is technically legal here in New York, but you can't buy it, you can't gift it, you can't grow it. There's no way to get it. So if you walk into half the shops around here, you can just buy it under the counter. We have no idea where that's coming from. It needs to be not a black market, not a gray market. They need to legalize it for good. Finally, just legalize it and regulate it like onions, like Larry Sharp, my friend, always said, running for governor here in New York. This whole idea of we're going to set up a commission to set up retail licensing, and then 18 months after that, you can grow your own. All it's doing is catching people into the system. Now, it's not as big of a deal, but they're in the system now. People are still being arrested for it. People are still being brought into family court for it. You know, there's cases being filed because people are growing marijuana in their home, and they're being brought into family court for, you know, drug possession around their children. You know, this is still happening, so we have to stop that. And then I think the next step would be to do that for all drugs. I think we need to end the drug war overall. We need to defund the cartels by ending the war on drugs. You know, victimless crimes should be an oxymoron. And I know this isn't directly public defense related, but I would gladly put myself and a lot of my colleagues out of business if it meant that we weren't prosecuting the drug war anymore.
Excellent. Mark, your thoughts?
Yeah, Pat, to deal with it, I mean, if you want to educate the public, that takes a lot. And quite frankly, a lot of the public doesn't want to be educated about it because it's kind of it's only interesting to lawyers and people in the system until you get caught in it. And so to me, I think a very important thing to do is to limit the caseloads of the public defenders who handle misdemeanors so that they have adequate time to educate their client about what the effects will be. If you have too many clients, I don't care who you are, if you've got so much going on, there's going to be pressure to take shortcuts. There's going to be pressure to not tell them a lot, just enough to keep from being accused of ineffective assistance of counsel. That can be proved. So the more time they have to say, hey, do you really want to do this? Tell me more about who you are, what it is, what do you need? If you committed the misdemeanor, why did you do it? Maybe I can get the deputy prosecutor to agree for a 6-month treatment program. I mean, we've got some drug courts here where that's what they do. So there are some opportunities out there, but you have to have the time to figure out what your client needs, what will help them. And, you know, like I said earlier, most of them end up with a conviction of some sort. What I find to be the thing prosecutors do too much is overcharge. But, you know, oftentimes, yeah, they did something wrong, but now you're saying it's way worse than it is. So your fight is on that. But you've got to work with these people and then convince the prosecutors and the judges that this is to keep the guy or gal from reoffending. Yeah, they did it. They'll admit it. You can prove it. But let's don't put them in prison. Let's just don't give them a year's probation with all types of weird arcane rules. Let's create a program which will help them change their life and not reoffend.
You brought up a great point, and that's overcharging. It's interesting because I'll just say this. I'll keep it opaque. But Chas and I are actually, Chas, I guess you could say you and I are involved in a case, well, where we each have a role. Chas as a defense attorney, and I happen to be a witness. And listening to the state issue these, having been a witness, literally firsthand, feet away, listening to the charges that the state came up with was astonishing. I said to myself, what movie? Was I in the other theater? Did I miss this movie? How much of a problem does that represent to all three of you? And Chas, why don't you go first?
I mean, just the fact that you got to say that to the officer who was reading the so-called facts 5 minutes after he read it was the highlight of my day that day. But but that's a problem because most of the time you don't have cameras, you don't have journalists that are going to be at the scene of these incidents to be able to put that in there. Luckily, in this case, and I think ultimately, I'm going to hope it's going to work out the way it should work out. Is that the cameras that were there, the witnesses that were there, all seem to be pretty upstanding people, maybe with the exception of you, Pat. But but I think that this is a big problem because everybody always says the way the cases are won for the state is the writing of the reports. The way the police write those reports a lot of the times dictates how those cases go. And if you weren't there, or there was nobody else there, and you read that report, you might have thought there was a riot that happened in Cumberland, Rhode Island that night.
Right.
And when in fact there were people reading the Lord's Prayer and saying the Pledge of Allegiance. So and that's not an exaggeration. That's not an exaggeration.
We have it on tape.
Any step of the that's not by any step of the imagination. So, that it's a problem when that happens, big time.
Well, and there was the Britt case, of course, too, in Rhode Island, which is, we're talking about some notorious cases, but the point is real. Jonathan, in family court, do you see that type of over prosecution?
So yeah, not in the same way. The main form of over prosecution is when they file a case that doesn't need to be filed. Like ACS might be doing an investigation that hasn't come to court yet, where they're providing support, and a parent might miss an appointment. They tell them like, hey, we're going to file a case against you unless you get therapy. They miss a therapy appointment, and all of a sudden there's a filing. Another way they can do it is when they put a petition in. When they do their filing, you'll read through it, and it'll be clear what the main issue is. This person hit their child with a belt. Okay, that's paragraph 1. And then paragraph 2 will be like, well, sometimes this person also smokes marijuana. And paragraph 3 will be, oh, and they're not in a drug rehab program for smoking marijuana. And then paragraph 4 will be, in 1990, they were arrested and convicted of smoking marijuana and, of X, Y, Z, 30 years ago. So a lot of times you'll find a petition, and just the nugget of what we're talking about here in court is right there at the top. And then you read through all this other stuff and you realize, they're just doing that so the judge can be told, like, this is a bad person. But you don't have to think about this too hard. You already know who this is. You already know you're going to take their kids away. So don't think too hard.
So Pat, what I've observed, and this goes to something that I may be a little radical about, although I do plea agreements for my clients because it may be in their best interest, the plea agreement system is really broken. And the problem is that with the overcharging, a lot of times I think they overcharge one, it helps their statistics. Yeah, we charge a lot of people these horrible crimes. But also, you can say, oh, we'll drop this lead charge if you plead guilty to a couple of other things. And here's where the problem is. And almost every criminal defense attorney I know has this happen every now and then, where their client is, and the evidence suggests strongly they didn't do anything that was illegal, or well, they may have done illegal, but criminal. But the pressure is, well, we go to trial, and if I plea, I'll get 1 year in jail. If I don't plea, and we get to trial to this really massive felony, I'm going to get 30 years in jail. Mm-hmm. And guess what? That forces people to lie. Well, that's not justice. So they really should be better at deciding what to charge. And I think the plea agreement system has broken the criminal justice system because it has the wrong incentives. The incentives should be justice. What did this person do? And if they did break the law and it's criminal, what should be the sentence? It shouldn't be these gamemanship like oh my gosh. Well, the trucker in Colorado, that was a big case where he got 110 years.
Right.
I think he was offered plea agreements that were a lot less. Not as good as the governor eventually did by commuting it, but that's what he was facing. Like, well, I don't think I did anything wrong. I don't think I had the intent. I don't think it was criminally reckless. You can argue about that all you want, but you've got a client saying that, and there's some merit that he was overcharged.
Particularly,
and we get
Jonathan, go ahead.
Sorry. Well, I was just going to say, we get a similar issue in family court where they'll say, okay, we could start trial today, and it will take months and months to finish because it's a big case. And then at the end of it, you might win or lose, and then eventually you'll get your kid back even if you lose. Or you could take a plea and your kid can come home today. Like that's often how it is. And so they're holding people's children over them. And another way that they do it is if we get past the point where my client has been, has a finding of neglect or abuse, and they're filing to terminate their parental rights, which can happen pretty quickly after just 15 months after the case is filed. They can be doing a TPR, termination of parental rights. And what they'll do is say, hey, if you do a voluntary surrender where you give your child up and let us terminate your rights, we'll put in an agreement for visits so you can still visit your child even though you don't have parental rights. But if you go to trial and lose and your rights are terminated, there's no chance of that. There is no legally enforceable visitation agreement that can be entered into. And we actually, I mentioned this earlier, we got a bill passed in New York here that made it so that you could still have a visitation agreement through the court with your biological child if you go to trial, so they can't use that coercion to make you take a deal, and the governor vetoed it.
The question begs, and I'll ask Chaz this first, and let's go around the room. Should routine overcharging be considered prosecutorial misconduct, and should there be an avenue for which prosecutors, very often working in highly politicized environments, should in fact suffer penalties as a result?
So I'm going to consider myself a radical, just like Mark considers himself on this. And as a former prosecutor, I'm going to say this directly. It is a epidemic in Rhode Island, the overcharging, and especially when you combine it with the so-called probation violation system, where they use that as basically they call it in the Supreme Court, the sword of Damocles hanging over your head once you get into that probationary system, that just waiting for you to mess up again. The coercion is off the charts, and it's routine in the Rhode Island Attorney General's office to overcharge. Especially they'll whack you with a felony, a major felony. They'll put a few other misdemeanors in there just to kind of make it, just add on to it. And then they'll say, listen, we'll either drop the felony, you complete the consecutive misdemeanors, then you're in the system, you get your probation, you won't go to jail, or you go to trial, and, some of these felonies go 30, 40 year maximum penalties. And depending on the judge you get, that's not an unrealistic outcome in many of those cases. But they're using this probation violation system, which is a much lower standard of proof, just like Jonathan was talking about in family court. It's a preponderance of the evidence. So if you got a suspended sentence or probation, a few years ago, and then you just got arrested for a new misdemeanor, let's just say you have 5 years of probation hanging over your head, you might get that full 5 years of probation just for getting a misdemeanor, when the maximum you could have gotten just for having that misdemeanor penalty, that misdemeanor offense, is a year. And most people do not want to take that risk to go to that violation hearing or go to that trial. And then, even if the violation hearing kind of follows along with that trial, because the chances of you being successful on the defense side on a violation hearing is slim to none in Rhode Island. And I think it is misconduct for a prosecutor to either recklessly or knowingly overcharge a case in order just to, quote, get something. To either pad their stats or just to show that they have, they've so-called done their job. So I'm a big believer in what Mark has said earlier, that overcharging is a major problem in the criminal justice system.
Jonathan?
Well, I mean, all lawyers are professionals, so we have a duty to our clients, and it's important to remember, as prosecutors love to say when they go on the record, not in family court, but in criminal court, they represent the people. Their clients are all of the people, and all of the people should have the right to hold them accountable when they're acting improperly. I think we need to make it much, much easier to bring charges and violations against prosecutors. Overcharging is just one of many reasons. I mean, there's been a lot of highly publicized cases lately where prosecutors have just done crazy stuff. The guy was pointing the gun at the jury. That was a standout moment where I was like, oh wow, that you would not get away with that in Bronx County Family Court. That wouldn't happen. But yeah, I mean that's just an illustration of the larger issue. There are rights violations going on all the time, and judges find that there are rights violations going on all the time, and then nothing happens about it. I've never seen a sanctions case go through, and I can think of many cases where sanctions should have been levied against a government attorney in family court.
Wow. Mark, any other thoughts on the subject?
Yeah,
it's a powerful one.
It is, and what's overcharging is subjective. So how do you define it? When is the prosecutor is acting in good faith or not? There are a lot of prosecutors out there who don't overcharge. I can tell you who they are. There's many that do for that. What I do know is that if they have more trials and it's harder to do a plea agreement, then that would change things dramatically, because if you overcharge, you're going to have a trial, because your choice is plead guilty to the judge to all the charges or have a trial. Plea agreements are beneficial to my clients and some clients. I've had many a nice over a beer or a scotch with fellow attorneys about what do we do about this? Are plea agreements unethical? Or are they just, how do you control them? I mean, there are times when it is a good thing. Everybody saves time, money, and the evidence is there, and you can get a sentence that everybody's happy with and present it to the judge. So it's something that has to be done. I think another thing that could help with the overcharging is when public defenders have manageable caseloads, they have time to do things like call prosecutors on it. Go ahead, let's have a trial. I mean, you may not want one. Your client, though, may be wanting to have one. And sometimes that's not a threat. It's just you've overcharged. You can't prove it. Sometimes that discussion will cause the prosecutor to change their minds and drop a charge that's too onerous because it's not correct.
Mark, you provided a wonderful segue, I think, into the next segment of the program. In the time that we've got left, I want to talk about solutions. And you talk about, and you speak provocatively to the issue of being able to force a trial in order to truly get justice, because it strikes me as an outsider that unless, and it's almost cliche, the facts of the case are heard, unless there's an in-person, if you will, confrontation between the person accused and the jury of his peers, and unless that exists, how can one really get justice? And the saying, the official saying of the coalition is, you guys have all heard this, in the halls of justice, very often justice is found, in fact, in the halls. And so in order to move around that and away from that, it becomes a question of resources. And I guess in a criminal justice system, and I'm talking about the larger, if you will, the larger universe, where untold money is made from fines, there's all sorts of funding because of what we all agree, and perhaps another show for another time, is the failed war on drugs. There's enormous amounts of money flowing around. And yet it strikes me that so little of this, it reminds me of casino gaming. We all love casino gaming, right? People should be free to engage in it. Well, we're supposed to allocate a little money in case we generate problems with that. Well, we've got this enormous machine that is like a vacuum cleaner. I'll quote a former presidential candidate, right? That giant sucking sound you hear are these traps, these landmines that exist everywhere, from traffic violations to minuscule amounts of drugs, which suck someone into a life-changing system. So what I want to throw out to you folks is a question. The first first point, obviously, is the money. So I'm wondering, in each of your jurisdictions, because they're so wildly different. We've got, this beautiful city in the Midwest, which suffers from a lot of the same issues that everyone does. The opioid epidemic, alcoholism, family issues, the stress all created by COVID. Yet at the same time, we've got an attorney here from Bronx County, New York. And at the same time, we've got someone from the Golden Hills, if you will, of New England, where none of these problems ever exist, right, Chaz? So
None.
what, just in sort of bullet points, what is a typical, and it's hard to pin this down, I understand this, but what is a typical cost of a private defense? What kind of money do you think is being spent on public defense, and how do we get more money into the system away from the machine that seeks so aggressively to bring people into the system? Chaz, why don't you go first?
So, the price for a private defense, it's really going to depend on what your evaluation of how that case is going to play out. You got to have that conversation with your client right up front, kind of get what their expectations are, set their expectations, what the charge is, and how much time and effort you think you're going to have to put into that case, because that's going to determine how much you're going to have to charge your client and how much time they're going to be taking away from the rest of your practice. And that's from a private perspective. So, from a public defender perspective, in Rhode Island, the public defenders, the full-time public defenders are making a decent salary, but they are completely overworked, and they need to have better resources to be able to manage those cases and manage the situations like we talked about, the overcharging, the collateral consequences that go into taking a plea to maybe a lesser charge because it gets you out of the can that day, or it gets you your kid back, as Jonathan was talking about. Kind of have more opportunity to go over with them what these ramifications are, and it doesn't exist. I can tell you from the perspective, I quoted those numbers before. You just don't have the ability to have a lot of those conversations with your clients at that level. And I can tell you, even at the indigent defense that I do, it's very hard for you to explain to your client that, this sounds like a really good deal, but these are going to be the potential consequences of going on down the line. And if you don't fully understand that, if they don't fully understand that, you're going to probably end up back in that system, and it's going to be a lot worse for you the next time when you come around, simply because it was a lack of understanding. So, they need to increase in Rhode Island. They need to increase the funding for the indigent defense, because they're not getting new people to do that. They're allowing people who have no experience in trying major cases or even misdemeanor cases onto those lists, and it doesn't do the client any good. And the big reason for that is just simply because they don't pay the lawyers enough. And I hate to say that, but it's a sad reality of the system. So that was where in Rhode Island I would suggest they certainly try. And I know, like I said, the family court chief judges tried. They're trying in the district court. They raised a little bit, but it's a lot of lawyers just won't do it because it's not worth their time and money.
What if you could, in Rhode Island, if you know this, what is the benchmark for qualifying, as a defendant for a public defender?
So, basically they have a threshold. I don't know the exact number, but basically you are making below a certain amount of money, or you don't have a job, you don't own a home. These are the basics that they're looking for. So, the public defender's office in Rhode Island is really good about kind of stretching those boundaries and trying to take as many cases as they possibly can to make you financially eligible for the services of the public defender. So there is that segment of the clientele, though, that I would consider them the working poor. So they have a job. They're not making a lot of money, but they're just above that threshold where they don't qualify financially for the public defender's office, and their choices are either try to go hire a private attorney or go pro se on their own. And going pro se in a criminal case on your own is, you have a death wish essentially, in the way these cases work out. So, it's one of those situations where the General Assembly really has to be getting involved. The public defender's office has been vocal about it. And, the judges do their best. I think a lot of the judges do their best with the people who do decide to represent themselves to try to kind of push them into the direction of where they need to be going, and try to go re-interview with the public defender if your circumstances have changed. But that's one of the toughest areas that they face.
Jonathan, now, of course, we're talking about family court as opposed to Chaz's primary exposure, which is to criminal court. But so sort of the same, if you're in a situation where you're a parent and you're facing, for any one of a number of reasons, parental, loss of parental rights, and in the Bronx County, what are the sort of ballpark limitations on what you can make to defend, to qualify for public defense?
So I will say this: I've been on intake, many times. I've been in arraignment many times. It has never come up as an issue. I've never had someone who was brought in to Bronx County Family Court. They were questioned as to how much money they make, and it ended up they made too much to qualify. They get asked every single time. My guess would be it's in the $30,000 range. Although I guess that's probably something I should know, but it just never came up. So I never actually looked into it. But if someone does say, "Oh, I make this much money," they'll say, "Well, who do you support? Do you own any property? Do you have any debt?" And they almost always find a way to make it work. It has not come up. The bigger issue is something that has come up a lot in this discussion. I work for the Bronx Defenders. We usually get one of the two parents that comes in. If there's two parents involved in the case, sometimes there's two parents and an uncle and an aunt. So we get one of them, and then an independent attorney, an 18B, gets assigned the other one, or the other two, or the other three. Sometimes there's 5 or 6 respondents on one case. And the Bronx Defenders, we have social workers who work for us. We have supervisors. We have people who can cover for us when we're out sick with COVID, like what happened to me when you guys graciously rescheduled this. The independent attorneys usually don't have that. And the number of independent attorneys, the 18B panel in Bronx County Family Court, has gone from about 30 to about 5. And I know one of them mentioned just casually the other day that she has almost 500 cases. And I thought I was really overworked because I have about 65. I have about 65 cases. And I feel very overworked. It's not the most I've ever had. I've had in the 80s. And I know back in the early days of the Bronx Defenders in family court, there were people at 3 figures, low hundreds, but not in any recent time has anyone in my organization had that. I could not give anyone fair representation if I had 500 clients. I couldn't do it if I had 150. I think if I had just double what I have now, I wouldn't be able to handle it. I mean, I wouldn't be able to do anything for anybody. I would just be in court all day. I mean, I'm already in court all day. No one can get a fair defense when that happens. So I don't know how much the 18Bs, the independent attorneys, are paid, but clearly just knowing supply and demand, it's not enough. Or there'd be more of them. People would be flocking to do this job because there's ample work.
Wow. Mark, your thoughts?
Well, my thoughts, it's hard to tell how much. There's no typical on what a private attorney charges. It depends on the case. I'm at a point in my career, I'm all hourly. So I can give them estimates, but I don't guarantee it because you don't know what the state will do. But you can give them a rough idea. It just depends. But the more serious the crime, the more costly it is. That's why you often, with people charged with very serious crimes, robbery, even if they have some assets, they're found indigent because they're going to be asked for a retainer of $30,000, $50,000, $60,000, $75,000 because it's going to take that way to be able to get them what they want. Maybe they have to have a trial, etc. If you're doing a public intoxication case, that's going to be a diversion. You just want to make sure that your client is treated fairly like anybody else. That might be $500, but it depends on the situation, goals of the client, etc. on that. When it comes to getting a public defender in Indiana, it's really under the judge's control. And most judges, some are considered generous because they think public defenders help move the caseload. They've never said that to me, but we suspect it by their actions, that because they give everybody a public defender, it speeds things up. I know other judges, if they think they're on the bubble, they'll say, well, come back in a week. I want you to talk to 3 criminal defense attorneys and you tell me what they said they would charge. And I'll tell you whether I think with your assets and your job, you can afford it. And sometimes they come back and say, I got $5,000 request for the case. And the judge will say, you can't afford that, public defender appointed. I got $250. You're making enough money to do that. Hire that guy. So it just is really all over the board, and there's no set standards. It's hard to do. The biggest complaint that I hear from my public defender friends is, and this has happened before, where they drive up in their beater of a car and their client pulls up in a really nice car, yet they have been appointed their public defender. So it's like but in every system things will go wrong, but there are people who will lie to do that to get a public defender because they don't want to spend the money. But I would say most people who do get public defender, they don't have much money. They don't have a very good job, if they even have a job. And it would be difficult to pay that because, as we talked about earlier, $150,000 to go to law school, you got to pay that somehow.
Yep, you certainly do. Well, gentlemen,
so the prices are high.
I want to close out the evening, if you will, on a productive note, and your contributions tonight have been incredible. And again, the combined experience of all of you, from Jonathan, the youngest, on up to, well, Mark and I, we're sort of senior statesmen, if you will, in our respective worlds. But if you could bring to the audience in sort of a closing argument, if you will, if there was one significant reform that you could just bring to bear now in your respective universes, and again, you all occupy very different worlds within the same bailiwick, what would that one reform be? And Chaz, I'll put you on the hot seat first. What would you do if you could wave that magic wand?
In the context of our discussion here tonight, Pat, I would urge the judiciary to reform the payment levels for the conflict attorneys, for the indigent conflict attorneys, because they just are losing them by the day. They're losing them by the day, and the people they are keeping, for the most part, not all, certainly not all. There's plenty of good ones. But the people they're keeping are the ones that are just scooping them up, billing the state as much as they possibly can, and not really having their client's best interest in mind. So I would urge the Rhode Island Supreme Court to revise those payment rates, because they're the ones who set it in Rhode Island, and they have not, with the exception of misdemeanor cases in the district court, they have not moved since 2013.
Wow. Well, Jonathan, your thoughts?
Without repeating anything we've gone into already, I think the one change I would make in New York, it would be funding for early defense representation. And in family court, what that is, when the agency opens up an investigation into you, your name goes on a record. You have a liberty interest here. They put your name on the state central registry, and it won't go away. It used to be for, I think, 20 years. Now it's 8 years. But you don't have a right to a lawyer at that point until the case is actually filed in court. My organization gets private donations and goes out and tries to find those people who are being investigated, give them legal advice while they're being investigated, and we see a massive reduction in the number of cases that end up getting filed, and an even bigger reduction in the number of children who end up being removed. And the reason is, a lot of people don't realize what situation that they're in at that moment. They don't realize the importance of, if ACS comes to your home and says, we want you to do this, and you don't do exactly that, what is going to happen right after that, because you haven't spoken to a lawyer about it. We find when you're able to speak to a lawyer while you're under investigation, but again, when you're under investigation, there is a liberty interest there, because your name is on a list there and it's not coming off. So that's what I would do, is have funding from the state for legal representation while you're under investigation by any child welfare agency.
Excellent. Mark, your thoughts?
Well, I've already talked about misdemeanor funding in Indiana so that we have more misdemeanor public defenders. But this is a little different. And so this is either first or second, and that is in Indiana, at least, and I think in a lot of other states, it starts moving when you have your first initial hearing. And there's so many things you can do and learn at that initial hearing, and so many things you can do to screw up your life at the initial hearing, that there needs to be representation of everybody at initial hearing, even if it's a temporary public defender. There's got to be an attorney who knows what the traps are and can tell the client, shut up, is one of the things.
Yes.
Or they can bring up to the judge, there's a huge flaw already in the documentation presented by the state. And if you aren't an attorney, you'd have no idea. Yet you could have gotten rid of the case that day.
Wow. Well, gentlemen, I can't begin to express my gratitude for your contributions tonight. Calenda, attorney at the law firm of Inman and Torgy in Coventry, Rhode Island, where he specializes in criminal defense, but also civil litigation and constitutional law issues. Jonathan Howe is a staff attorney with the Bronx Defenders and spends a good deal of his waking moments at this point arguing on behalf of folks from literally every background, every situation, every type of prosecution in the Bronx County Family Court. And just again is a remarkable entrant into what I'll call not just criminal justice, but just criminal justice reform in the realest sense. Of course, Mark Rutherford, an owner of Thrasher, Bushman, and Vocal in Indianapolis, Indiana, a lifetime spent literally at the highest levels of constitutional law, yet at the same time a deeply personal involvement, if you will, not just as the head of the Indiana Public Defenders Commission, but as someone who continues to be involved at an organic level in the individual's defense at virtually every level of society. All three of you are just such credits to the legal profession. I've really enjoyed tonight, and I hope, well, number one, in a perfect world, I'd like to see all of your reforms happen. All of us in this conversation are political. We're all activists at some level, and let's find a way to continue this conversation, not just in the media, but also in the very, very real worlds that all of you occupy. My name is Pat Ford. I am the general manager and host of the Coalition Radio Network. I thank all of you for joining us, because as we like to say, we are the Coalition. We, as always, are loud and proud. We are always free of any vestige of outrage porn. We'll always continue to be civilly disobedient. This show will live on in perpetuity at facebook.com/Coalition Radio, on the mighty, mighty Twitter at Coalition_radio, and of course, in our YouTube and all the other alternative forms of social media, as we try to take this argument to even a higher level. Thank you all for joining me tonight. And all of you have a wonderful evening. Good night.